Hi, this is Andrea Kane, and I'm here with you for HIT 421 Legal Release Information. And we are now on week number 5. We're focusing on consent for treatment or consent to treatment. If you want to follow along in your book, we are starting on page, oops, I just went past it, page 139. If you look at your syllabus, you'll see we're focusing on unit objectives 9.4.1 through 9.4.14. The law recognizes the right to control one's own body, including making medical decision-making, and this is covered by federal and state statutes, case law, as well as common rule. Rights to consent can be affected by age, competence, and emergency circumstances. Treatment without consent or without proper consent can result in liability for negligence or battery, or both. A broad process that can be in written or non-written form and vary in terms of how much information is provided is how consent is defined. In most cases, consent involves a patient's acknowledgement that he or she understands a proposed intervention, including that intervention's risks, benefits, and alternatives. There are 3 types of consent that we're going to talk about. The first one is express consent, then implied consent, and then informed consent. If you look at page 140, these are here, and they are defined. Express consent refers to consent that is communicated through words, whether oral or whether written or spoken. An individual may show express consent through written documentation or by orally agreeing to an intervention. Although both forms of express consent are valid, written consent is more desirable than oral consent from an evidentiary standpoint. Implied consent refers to consent for medical treatment that is communicated through a person's conduct or some other means besides words. For example, most physicians do not directly ask the patient for express written or oral consent prior to conducting a basic physical examination or minor office procedure. However, the patient still communicates consent through his or her conduct as exemplified by scheduling and arriving for the appointment and submitting to the exam or procedure without objection. Implied consent is most appropriate for interventions that are non-invasive and very low risk. As interventions become more invasive or risky, providers should obtain a patient's express, written, informed consent. For implied consent to be valid from an evidentiary standpoint, the patient's conduct and surrounding circumstances must create a reasonable belief that consent was given. A good example for implied consent is a patient who shows up to the emergency department. The hospital is providing emergency services, and if someone comes and checks in or says, I want to be seen, that is their consent to be treated. Informed consent is where you get into the risk, benefits, and alternatives. You have to have someone who is competent to give consent. The consent must be voluntary. It can be oral, but it's preferred, again, to be in writing for evidentiary reasons. One type of informed consent would be for an invasive surgical procedure. There are also informed consents that are, so to speak, of like a consent to treat that you might sign if you go to the hospital, where you're signing to basically say, I want to be treated. Okay, we talked about express consent, we talked about implied, and we talked about informed. And when you're talking about informed, make sure you think about risks, benefits, and alternatives. Those are the 3 major components of informed consent, above and beyond the fact that the person has to be competent and their consent has to be given voluntarily. not sure if we have talked yet about IRBs, internal review boards, and human subjects research. If we haven't already talked about that, that's something that we will definitely be talking about in this chapter and in other places. This begins on page 142 at the bottom. And I'd like you to read through your book for all of this, because your book is going to give you the most detailed information. But basically, anytime someone wants to participate in human subjects research, they have to sign a specific consent for that. It has to be voluntary. It is something where there has to be a lot of information about the study disclosed to the patient, so that they understand risk, benefits, and alternatives. And this just talks about the background of it and what all needs to be involved with it. And any type of study that they want to do, or any type of research that someone wants to do, it has to go and be before the institutional review board, and they have to determine whether or not that research is appropriate and whether or not it can move forward. So let's talk about informed consent and how it applies to HIPAA. HIPAA addresses informed consent through its authorization requirements. So it's somewhat separate from IRB and human research study consent forms, which makes perfect sense. There are times when informed consent is not possible, and the law usually provides what those exceptions are. And it includes emergency situations, when someone's not competent or when they're not conscious, trying to get the next of kin or whoever's responsible for that person, their consent. Again, governmental actions. Sometimes there are governmental actions that basically say that override consent. You hear about it most often when you're talking about blood alcohol levels for driving while intoxicated or driving under the influence of a substance. Sometimes you'll see that informed consent, there's exceptions if someone's mentally incompetent, or if someone is at a point where their mental illness has become so extreme they're not capable of making a judgment, and they may be involuntarily committed to a behavioral health or substance abuse program. And even though IRBs can use waivers, that's not recommended. There's a lot of risk that comes with research. So if you are ever involved in research in an area where that's done, you'll learn all the specific ins and outs of what must be included and how it has to be approached. Advanced directives. This starts on the bottom of page 147. These are legal documents that specify an individual's healthcare wishes in the event of temporary or permanent loss of competence. They can appoint another person to make decisions for themselves, such as a healthcare power of attorney. A healthcare power of attorney is different than a legal power of attorney. Legal powers of attorney don't always have healthcare power of attorney, so you have to really watch that. Advanced directives can include a living will, and they can also specify what types of equipment procedures to prolong life that the patient does not wish to have. in some ways, a do not resuscitate order is kind of dovetailing with that. Then you get into powers of attorney, and we talked about healthcare, power of attorney versus regular legal durable power of attorney. Those are two different things. The powers of attorney are basically a legal instrument used by a person to grant legal authority to one or more agents to make certain legal and financial decisions on behalf of them. The person has to be mentally competent when they enter into a power of attorney, meaning that the person who is saying, I want someone else to be my power of attorney, is mentally competent when they make that decision. A POA can be revoked. And it says here, if the person becomes incapacitated, the POA would be void unless it is brought back through the courts. And then this goes into the power of attorney for healthcare decisions. And it's essentially the same thing as a healthcare proxy. It authorizes someone to make personal healthcare decisions if the authorizing individual becomes incapacitated. So unlike the power of attorney, it's in effect when the principal is incapacitated. Again, the person has to be competent when they're executing the healthcare power of attorney. It can be revoked, and it can also have an expiration clause in it. Living wills are another legal document, and that is about direction as to medical care if they are incapacitated or unable to make personal decisions. It can also be called advanced directive, healthcare directive, advanced care plan, living will. Those are all the same names. State requirements usually include some specific things, and they're specific to each state. So if you had a living will in another state, you may want to go ahead and get a new one when you move to a different state so that it's in alignment with the state's law and will be honored without question. Some of the things that are limited in terms of care are whether or not someone wants to be put on a ventilator, whether they want artificial nutrition, hydration, whether or not they want CPR. And again, a living will can be revoked. And a copy definitely needs to be with the physician in an office setting as well as in the hospital medical record. Then there's DNR orders. This is a no CPR, no code blue order. It's an exception to a universal standing order to provide CPR. It pertains to emergency situations only. Patient or representative signs the form in addition to the physician order. It can be revoked, but it definitely has to be preceded by that informed consent process of risks, benefits, alternatives. And these days, every hospital and nursing home have DNR policies, order policies on how they handle those. PSDA, Patient Self-Determination Act. This applies to all providers who receive Medicare or Medicaid funds. It basically means that they have to inform patients of their legal right to make medical decisions, including the right to create advance directives. They have to document in the health record the existence of any advance directives, educate staff and community about advance directives, not condition the care provided based on the presence or absence of an advance directive, and ensure compliance with state laws regarding advance directives. Uniform Anatomical Gift Act. This has to do with organ donation. Anytime you see anatomical gift, be thinking organ donation. This outlines the making of anatomical gifts by people designated to make decisions about the decedent's remains. So, for instance, if you really strongly believe in organ donation, you want to make sure that your family is very aware of that. In some states, there's a question that they can put on your when you go to get your driver's license or renew your driver's license, you can have on there whether or not you want to be an organ donor. When someone dies, the process in the hospital is that there's someone designated to contact a 24-hour-a-day, 7-day-a-week, 365-day-a-year hotline. And you have to call into the hotline, you have to document who you talk to, and you have to explain about the patient's physical situation and their illnesses, their diseases, and all of that. And they will walk you through what is appropriate for this person to potentially be an organ donor for. Some patients aren't eligible to be an organ donor for anything at all. Others, it may be eyes. Others, it may be other organs. It just really depends. States do not have to follow this act, but then they have to have requirements for obtaining informed consent for organ donation. So a lot of states choose to follow the UAGA rather than have their own set of rules and their own follow-up process. So let's move on to who can consent. And this is on page 154 in your book. Competent adults. You have to be competent in order to be able to consent, and you also need to be an adult. There are exceptions to this when it comes to minors, and we'll probably talk about that a little bit further down the road. But competent adults can consent. They need to be at the age of legal majority, which varies per state, so you need to know what your state's rule is about legal majority. Competent adults may refuse to consent or authorize withdrawal of treatment, and you need to make sure that that's documented in the medical record. The medical record is the sole source or the primary source for documenting any decision to withdraw or forego life-sustaining medical treatment. And then this is talking again about organ donation, and that when you do your durable power of attorney or your living will, you can make sure that you put in there that you want to donate organs if it's possible. Incompetent adults are adults who were once competent and who have executed advance directives, or adults who were once competent but did not execute an advance directive, or adults who never had competence. Incompetent adults cannot give consent. The decision has to be made by their guardian or a court-appointed person or their next of kin. If there are any known wishes of the patient, that has to be considered. There is a situation for temporary incompetence, and the idea behind that is that if the person is only temporarily incompetent, treatment can be postponed until they can make the decision, unless there's a substantial risk. And if there is, then their consent is implied due to it being an emergency. There have been major legal cases of incompetent adults, and you may recognize one or two names on this list. Minors. So let's talk about minors. Anyone who is below the legal age according to the state. They are legally classified as incompetent unless they are emancipated or identified as mature. They generally do not have the legal right to consent to or refuse treatment unless they are emancipated or identified as mature. In that case, you have to get the parental or guardian consent prior to treatment, unless it's an emergency situation, unless the state has statutes that allow minors the right to consent, unless the state statutes allow minors the right to consent for specific types of treatment, or a court or other legal authority orders the treatment. And one of the most challenging parts of looking at consent for minors oftentimes has to do with whether or not there's a divorce or legally separated situation, blended families, where you're dealing with step parents who may not have a legal right to consent. So it can get a bit challenging. So talking about challenges, consents can be challenged. The patient can say, I did not give consent, meaning that they're alleging battery. The patient may say they were not fully informed of the risks or other factors that would have been material to their decision, which they're alleging their negligence. They can argue that they were not competent at the time of completion, that the form was too technical to be understood, that their signature was not voluntary. They can allege physician misrepresentation, and it's not just the patient, it could be the family. So when you're documenting consent, what do you want to do? You want to have a general consent that's given at the time of admission for treatment. If you need a more specific type of treatment, such as for a surgical procedure, you want to make sure that the provider obtains that consent before the procedure is performed. It needs to be documented in the record. And then these are types of consent forms. There's a general blanket consent to treat consent form that's signed out at admission. And then there's shorter forms. An example was the human subject research. So the long consent form, a lot of times it's used with surgeries because it goes through the risk benefits alternatives. It's a lot more difficult for the patient to prove lack of informed consent with this form. But it takes a lot of time not only to design these forms, but also for the provider to go through with the patient and make sure everything is covered. All right, that is all I have for Chapter 8 on consent to treat. Hope you have a fabulous rest of your week. I'll be back to talk to you soon about week number 6.